Hello, I'm Dr. Daria Sharkova, and today we have the eighth webinar of our series, Houston, We Have a Solution, with Aaron Koenck, the Senior Associate from Clyde Co here in Houston. And the first question, Aaron, as usual, tell us a little bit more about yourself and how you landed in Houston.
Yeah, well, thank you for having me on. So, originally born and raised in Louisiana, Louisiana man, I guess, still to this day. Even though I've been in Houston for, I guess, 7 years now. Um, yeah, Houston was one of those places that I think attracts a lot of people from Louisiana. For me, attracted me. It's a great place to make a living, a lot of opportunity here. So I moved over here after law school to try to do some more interesting work that Houston had to offer. And since then, last 7 years, I've been practicing litigation and arbitration in Houston. I really enjoy it here. Met my wife here, coming up on our 1 year anniversary. So she's put up with me this long, which is a good thing. But yeah, so I really enjoy Houston. It's a place. That's I really think a great undersold location in the world. The weather's
Not that much on the soul anymore.
yeah.
And one more question. So I saw that you did your JD in Louisiana, but then you did your LLM in Houston. That's quite rare for US lawyers. Can you explain why you did that?
Yes, so Louisiana, as many people know, is a unique state in the United States in that it still has a lot of civil law versus common law as the English tradition tendencies and statutes, and we still have a civil code in Louisiana. Arguably, it's become more common law over the last 50 years. But for me, I wanted to learn more about other areas of law. So I ended up doing the JD, which is a civil law JD with some common law elements to it. And then my LLM, I had a strong interest in energy and also energy arbitration. So I came over to the University of Houston, which was offering a fantastic program at the time and still have continued to build on it for arbitration, particularly energy arbitration, international arbitration, and just the energy space in general, which makes sense as Houston is the oil and gas capital.
So the topic you suggested for today is arbitration versus litigation. It doesn't have to be either or. So I understand that you, in your opinion, arbitration litigation are competing. They kind of can replace each other or complement each other. Explain a little bit more why you suggested that topic and what's your general opinion on that.
Yeah, so the reason I suggest the topic is I see a lot of contracts being a disputes lawyer that, I don't think take advantage of either the arbitration side of things or the litigation choice of law or choice litigation provisions. And a lot of times they feel very just cookie cutter. It's like it's an afterthought. And I think a lot of, and frankly, no, but based on experience, that a lot of businesses would, if they would evaluate what their risks are, things, where they're conducting business, they would see that maybe we need a more complex litigation versus arbitration provision. And some parts of their businesses may be better served by an arbitration provision in their contracts versus other parts of the business may be better off with just a pure litigation.
So what are the main circumstances which would define the choice of arbitration or litigation for businesses?
This is why I think every business is going to have a different set of thoughts on choosing why I should choose arbitration as being part of my contract, or whether I'm just going to choose Houston, Harris County courts for our disputes. To be frank, a lot of them just feel like they just choose whatever their competitor may have had or somebody that they want to be like. has in their contracts. I would caution though, that's not necessarily the best way to do things. So
So let's go through the businesses. You're specialized in insurance, in maritime businesses, in energy law, right? So can you please just compare, for instance, in maritime, that's the best option under these circumstances, energy under these circumstances, just little examples.
yeah, so like maritime, one of the big issues we see down in the Gulf region of the United States and Texas is things related to Jones Act claims. Whether you have a Jones Act seaman, employee, etc. And those relate to more of the personal injury claims. And what we are seeing is a lot of nuclear verdicts for people. Depending on the circumstances of the employment and transaction, that maritime contract and that maritime employment contract may be better served with an arbitration provision, so you're not inside of Harris County courts. Whether you can actually do that or not is a little more complicated.
Harris County courts are bad.
Well, no, I wouldn't say they're bad.
Montgomery County.
Montgomery is less known for what we call nuclear verdicts, but Harris County is currently one of those jurisdictions in the United States. It's definitely known for nuclear verdicts. It's not that the courts are bad or anything like that by any stretch of imagination, but the types of risks that businesses are dealing with, we have to think about nuclear verdict risk. Now, that's more on the personal injury side of things. Now, on the commercial side of things, you have a different thought process, right? You may have confidentiality concerns, therefore a arbitration provision may be better. Particularly in the US, there is constitutional protections regarding open courts, etc. Yes, you can file certain motions, etc., to try to seal those proceedings, but that's not the default rule. More because in arbitration, right, you're going to have confidentiality is one of the tenets of selling points. It's not the same thing for litigation. So, as a business, I think you really got to drill down, just like you do on your due diligence with your partners, seeing if they have certificates of insurance or whatever it may be. I think you got to drill down on that dispute resolution clause also to determine what is the best for this transaction or series of transactions based on your risk profile as a business.
What about predictability? So we discussed confidentiality, that in the US arbitration is more preferable if you want to keep your problems confidential, right? It is confidential. What about the predictability?
Yeah, predictability. I will say this, you don't know what judge you're going to get when you go to litigation. And that's done on purpose. It's supposed to be a draw, unless there's only one judge, of course, in a more rural county in Texas. So having the predictability of you understand arbitration proceedings can be a different set of concerns and factors to think about. If you're used to AAA or any other arbitration institution, you'll have the predictability of knowing the costs. Okay, these are the rules. Again, confidentiality, you'll have that, you'll know before you go in there. So yeah, arbitration, that's a win on predictability because you don't quite know what you're going to get when you get to the courts. Yes, there's rules, etc., but they're a little more flexible in general because they have to serve a much broader purpose. They have to serve the general public and disputes from somebody didn't pay their credit card to a large loss off the coast of Louisiana, things like that. So those courts have to be able to be more flexible to handle a lot more cases. Whereas you get into arbitration, you can specify and build a predictable timeline. Cost also.
What about the scare of every US lawyer, the scare of the jury? The one the European lawyers don't have. Do you think arbitration has any advantages? for this
Um,
and for which type of claims, right?
yeah, so I think the current scare in general, from the jury is like they're gonna give you what we call a nuclear verdict. I don't think the jury is anything to be scared of. It's a different set of factors in handling a case. Um, because just because you don't have that in arbitration doesn't mean you should shy away from a jury or having your claims heard by a jury. But again, if you've had a past record of not having good success in front of a jury, maybe you think differently. So yeah, I don't think a jury is a bad thing necessarily. But I
What
understand.
about insurance claims? If you speak about the insurance companies, for instance, do you think that there's a place for insurance disputes in going to arbitration instead of litigation just for this reason that the jury may be too sensitive to some factors and not decide as calmly and reasonably as the arbitrators can?
Um, well, it also depends. There's various states don't allow um, insurance disputes.
Oh, that's
for the
interesting.
insurance company to be heard by arbitration.
What about Texas and Louisiana? Do they
Louisiana.
allow the insurance disputes going to arbitration?
So specifically Louisiana, and there's some caveats and small pieces to this, but in general, there is a statute in Louisiana that does not allow
Oh, that's interesting.
disputes
Mhm.
to be heard by arbitration. It's a public policy choice by the state. There are some decisions, and this is still being actively litigated throughout the country, depending on whether certain treaties will override that statute or not, and also federal legislation. Over
What
the
about
last
Texas?
Texas, I honestly I can't think off the top of my head. I don't think they allow it, to be honest.
Okay,
But I can't remember off the top of my head.
we can double check after. I remember when I started the arbitration class in Paris in Sorbonne, one of the first words that professor said that arbitration is cheaper and arbitration is quicker. And I'm not sure it was really true for the French courts because French courts are not expensive. Well, they have very long proceedings. What about the US? Do you think it's true that arbitration is cheaper and quicker than the resolution of disputes in the courts?
Honestly, I've had arbitration be very cheap and fast. But to be frank, I think a lot of that is because the lawyers were willing to work together to get to a resolution that was good for both their clients. I've had litigation that was very quick, very cheap, and now I've also had litigation that takes way too long. I think what it really comes down to is hopefully with arbitration that people are willing to work together at council, particularly the parties, to come to a resolution. And what I think that does is it allows that process to speed up. Because when you're in litigation, you're still on the judge's timeline. Again, they may have 10,000 cases that they have to handle because they're handling all of Harris County or for their judicial district. So they may have several thousand cases on the docket, and your case may not. It's not that it's not important, but they just have a
Yeah, it's the
order they have to
timeline,
do.
right?
Yeah, they have an order they need to do things. Where in arbitration, you may be able to speed it up, or if you need to slow it down too. And that really is up to the parties.
Can you think about a case which you would not recommend to go to arbitration?
Not really. I mean, if you can, I don't see an issue with it, other than I would say one thing that could be an issue. You don't have, so discovery is one of the big things in the
That's
US.
true for the US.
Whereas otherwise, depending on the rules, of course, right, and parties' willingness to work together, that not having documents you need to prepare your arbitration for your final hearing, that can be a problem. And you're kind of relying on the arbitrators and the other side, frankly, to be forthcoming with those documents. Whereas if you're in litigation in a court, you have a judge to go at least ask. Whether you win or not is a different question, but you at least have a
this
third party
option,
judge
right?
that neither person chose.
So imagine that you're in a meeting with general counsel and you ask, they ask you for a simple decision to go for arbitration or litigation. So what are the first 3-5 things you will ask about the case, about the dispute contract, the arbitration or forum selection clause? So whatever questions you will ask.
I think the first question that needs to be asked, and hopefully this is already known, but sometimes it's not. Ask the questions that help you as a lawyer, and this may also help the in-house person. What is the business? What are your risks? From there, once you actually understand the business, the business case, for example, and whether you're negotiating a provision, a dispute resolution provision, when you understand the business, then you can start actually negotiating that portion of the contract. Second, I would think about, do you have any risk of nuclear verdicts involved? If you don't have that risk, then there's no need to worry about that. Cost is another one, and then again, confidentiality. If you have various intellectual property that you're concerned about, maybe it's just easier to be on the default rule for confidentiality in arbitrations versus trying to go get that information protected by a court once you're in the court. So those are the kind of initial questions I would ask. Because once you understand those, I think you can really dig into the provision itself and understanding what you're gonna, how broad things are gonna be or narrow, gonna have any carve outs and etc.
You mentioned several times nuclear verdict.
Yes, a nuclear verdict.
Because we have in our audience we have the foreign non-US lawyers. So can you explain us what's that?
So nuclear verdicts are typically associated with a jury writing down a very large, what we'll call outsized damage award for that particular case. For example, I think maybe some of the Monsanto litigation that's
Tell us more about that.
So yeah, like or Johnson and Johnson, like there was various jury awards for I think upward of $1 billion, right? Arguably, that's an outsized verdict for what the alleged damages were. Obviously, the counsel for that got that verdict would say that, but so that is kind of a thought process on what we call nuclear verdict. And nuclear being is very large and explosive, right? Now, in the pure commercial property side of things, you have what we call a limited damage model. So it's kind of hard to be a nuclear verdict because like my car was broken. That's an easy example. And we all know the cars were, right? Versus what is a broken arm worth to? Because you have to, the hard thing for a jury is they have to value pain, they have to value suffering. And they have to value people. Because you have a fixed medical cost, they can say, okay, well, you had $1,000 worth of medical costs, right? So here's $1,000 for that as part of our damages award. Versus how do I place a dollar value on an arm that's hurting or something worse, right? Because it's intangible, that pain, suffering. It's very personal to that person. They know what they felt, but how does a jury understand that?
So it's not really a danger for contractual disputes.
It can be.
It can be.
In the sense of if your defense and indemnity obligations, because a lot of the energy space is around the world is a knock for knock. I pay provide people's damages from property and equipment property, and you pay for your own people. Sometimes those indemnities don't quite work the way people want them to, or I may have agreed to go ahead and pick up as a contractor, my subcontractors damages. So if that subcontractor gets hurt, they have a very large verdict, then you may be faced with a bigger set of liability than you expected.
I see. So the next question is, when and how do you think and what are the reasons that the businesses go for the wrong choice of forum? For instance, in your opinion, should have chosen arbitration, they go to litigation and vice versa.
I alluded to this earlier. I think why a lot of people do it is because they just end up copying another contract.
That's true.
Or they see X company does it, so that must be the best way to do it for us. And a lot of times that is just not the case. They have to really think about their own business, just like they think about their customers or their other services they provide. And also think about that part of the contract. And sometimes, honestly, I think people just get excited. They're getting a deal done, for example, they're bringing in revenue, and people don't want to think about the worst part of things, i.e. the dispute. So that's kind of an afterthought on.
I think one of the reasons as well, and it's true that it's very unpopular. Everybody knows that, everybody is aware of that, but people and lawyers don't like to talk about the copy pasting of the arbitration clauses. And when I did the research, I saw a lot of them, and I was in a good place as a researcher to say that, right? But as well, do you think that the reason is that in some companies, transactional lawyers are so separate from the litigation lawyers, and transactional lawyers, they don't really care what's going on after?
I think some firms, and some groups, because some companies do all this in-house, they have a legal department and transactional side, just the deal side. Yeah, they're not talking as well as they probably should be. But also I think it's how you present that information from if you're outside counsel or you're in-house counsel, how you're presenting that information to your transactional side. Because I think there's a bit of a say, well, here comes legal, they're trying to stop us. Well, part of my thought process here today was like, well, how does this dispute resolution actually just protect the business and allow this deal to succeed? And one of my favorite conference session that I went to, they actually put transactional lawyers and dispute lawyers on the panel. And I thought that was one of the most fruitful discussions I've probably ever heard at one of these conferences. Because people actually were talking about, hey, this is what we're seeing in the dispute side. How do we protect for that on the contractual side? That's best for the business itself. So.
You are a civil law and common law qualified lawyer, even if it's with a little American twist, let's say Louisiana versus Texas. Can you give us the examples, whether civil law, for instance, some cases in civil law when it's better to go for arbitration, or in common law to go for arbitration, or there's no difference?
I think it's just going to be mainly jurisdiction or specific. If you're in France, for example, it's going to be very different than you're in a civil law type jurisdiction. Now, keeping in mind that those civil law jurisdictions may not have some of the same concerns as the common law jurisdiction based on types of damages that can be awarded. So then again, your driver of going to arbitration or recognizing those risks may not even exist in the civil law jurisdiction versus that common law jurisdiction where that type of damage is available and that is a risk factor for you. You may want to stay out of the courts versus just going to arbitration. Does that make sense?
Yes, let's go to examples. For instance, let's go to Louisiana. That Louisiana allowed the award of this nuclear damages?
Yes, I mean, there is some very high profile cases from last year.
Mhm.
Where I think a subcontractor was awarded, I think, close to $400 million.
Can you tell us more about this case? What was the industry? What's basically the situation? What was the dispute and how it was decided?
Yeah, and this is all just from the news and what I read.
Because we don't know that. There are
Yeah.
lawyers from Europe, from India, from everywhere
Yeah,
listening to
so
us.
yeah, so for example, from what I remember reading about the case in the news, it was an employee that suffered a head injury,
Mhm.
and ultimately a jury decided that he was entitled to $400 million. I think it was 400 million. And there was the jury decided that there was some fault on the companies involved. Um, so and that's because the head injury, it's hard to, as I explained earlier with the arm injury, that it can be hard to value that pain. Um, so a jury has to make that decision. Now, there are, for example, in Louisiana, and a difference in Texas. Punitive damages are far more limited in their availability in Louisiana versus Texas.
Do you think it's because Louisiana is somehow civil law?
From what I recall, yes, that is exactly it. They don't, civil law doesn't
Mhm.
necessarily uh, care for punitive damages as a system, versus common law. It's just something that has developed through time.
What about the discovery? Do Louisiana courts allow discovery?
Yes, I mean, discovery is essentially the same pretty
Mhm.
much throughout the US. If you're thinking about scope of how it's done can be a little different, depending on your jurisdiction, which can also be a reason why you would prefer just arbitration provision,
Mhm.
because just if you operate in many different states where the disputes may also end up being brought in various different states, you may prefer an arbitration provision so you have that predictability of this is the process for getting information versus Oklahoma versus Texas versus Louisiana versus New York. You don't quite know how extensive that discovery is going to be and what the rules allow and don't allow.
Mhm. I see. So, for instance, if you compare arbitration clause versus forum selection clauses, do you think that forum selection, can you insert in your contract forum selection clause specifying procedural, what the procedural rules will be, for instance, New York, Louisiana, Texas, or it's limited somehow by the law?
I have never seen it limited beyond, and that doesn't mean people don't do this, I just haven't personally seen it.
Mhm.
I have never seen that dispute resolution say, okay, yes, we're gonna be in district court in Texas. And then limit to what, uh, how many depositions you can take. Now, the rules themselves do state that, for example, there are certain, I'm not quite sure if you can actually choose it, to be honest, but that is something to think about on carve outs, is like, hey, if this dispute is less than, say, the jurisdictional limit for district court, and you're gonna be in county court, or even if you're in district court and you want to choose a certain level of discovery, you can do that as the parties. So, and what that does is, for example, you choose level two discovery, um, or you're limited to it by rule, then for level one discovery, you're only limited to like 15 requests for production or 25, whatever the rule is now. And it does change a little bit throughout time. But yeah, so there is some benefits, or at least I should say it this way. Courts today are working to make discovery better for the parties because they understand that it is one of the big drivers of cost in the litigation system. And I guess we should make this point too. A lot of people don't know this. Like the American rule for costs is that generally speaking, unless it says otherwise in the contract, for example, is that each party has their own
Yeah.
costs.
While in Europe, for instance, in France, the losing party has to pay the costs.
Yeah. So you ultimately made that's at least the general, right? In
Mhm.
America, you have to generally be required to pay your own legal costs. So, which it's not fun if you're someone who says, well, I should have never been sued, and now I'm having to pay this lawyer all this money.
Exactly. Or for instance, I remember from my times at the SEC, I had a case of $10 billion. And as you imagine, the legal costs were huge in that case, right? So imagine if the parties have to bear their own costs, even the party which wins, right?
And that's why a lot of contracts, and a lot of states throughout the US allow you to
Recover.
enforce and recover. And some parties, because you don't know what those costs could be, they'll have in that contract, I get $5,000 or $25,000 worth of legal fees. So that way you have that predictability of hey, if a dispute does arise, I can get up to 25,000 if I win. But that also is a whole other can of worms in the US of what is winning. So
as we talked about discovery, when people speak about discovery, they often talk about the Americanization of international arbitration. What's your opinion on that? One, do you agree that there's this Americanization of arbitration in the world? And two, if you choose whether to go with discovery, would you want discovery in your arbitration? And if no, yes, why?
I hate to give a lawyer answer here, but I think it depends.
Okay, let's start with Americanization. Do you agree that there's Americanization of international arbitration? Because we speak of litigation versus arbitration today, right? So do you think that arbitration gets more and more similar to American style litigation?
I don't think it's just my opinion. I think leading arbitrators and would say yes, that is certainly the trend. To be frank, it's my understanding too. A lot of companies, that's what they want. Some of their cases, they want an American style litigator.
Why do you think they want it?
Why? I think they want this is speaking in general. I think they want the aggression,
because they've chosen arbitration, right? So they've chosen arbitration, but at the same time, they want to keep these features of litigation.
They may have chosen arbitration for the portability of the award and the confidentiality, and the fact that they're going to get to help ensure that, because to make the point of in the US, and can be a little different than civil law systems, where a judge here is a generalist, and they have to be, right? Because they have all these different types of cases. Where not, as an arbitration, you may get to put on a mechanical engineer, a plant operator, an accountant, somebody that spent 30 years negotiating this type of cross-border agreement that actually understands the business and the fine details. So they may have chosen arbitration for that, for the arbitration provision, but what they still want is somebody aggressive that's going to try to get the dispute resolved in a favorable way. Now, not every arbitration needs that, and I think that's where, as the advocate, you have to understand that too.
Yes, I remember the scare of my life was learning the evidence for the bar exam. And that apparently it's very helpful to watch some American TV shows to learn some elements of this evidence course.
Yeah. Well, and that's something else to keep in mind. Between the litigation versus arbitration is the evidence that may come in or not. There's well-established rules on evidence in the U.S. and a lot of case law that, in theory, yes, again, you never know what's actually going to happen in a moment, but sometimes I felt that it was going to be a little bit harder for an arbitrator not to hear certain pieces of evidence. Whereas if a jury heard that piece of evidence, I would be shocked and at least give me a valid point to deal with. So that is something to think about too.
Opposite question. What are the tools to keep the arbitration from turning into litigation in the arbitration?
Well, a well-drafted arbitration provision,
Mhm.
who you're choosing as your arbitration body, and who you're choosing as your arbitrators, right? Because if you have a concern that you weren't able to predict during the drafting of the arbitration provision, but once you get to the arbitration proceedings, and you have to pick your arbitrator. You may want an arbitrator that you or fairly certain that's going to not allow this to turn into American style arbitration. And then maybe pick an arbitrator that's not American, that is used to European style arbitrations or whatever it may be. So, and that's how I would kind of think about it, at least my initial thoughts.
I was thinking about the choice of arbitral institution as well, because I had this discussion with Janet about ICDR rules and AAA rules, and I was surprised that if in ICDR rules there are provisions on discovery, while in ICC rules, of course, there are no provisions on discovery. So depending on what the party wants, right, they
Yeah.
can choose ICC or ICDR. But the problem, as you've said, that when people insert these clauses, they don't really think about these details, right? They go with ICC because the other side likes it more, or this ICDR is more American, or they can just have some other very like superficial reasoning, right?
And I guess that's the point I think we're trying to make. The larger point today is go beyond that superficial dispute resolution clause. Really think about your business and how things are going to work. Okay, and I choose AAA. Okay, what does that mean? Or if I have an ICR, or if I chose the Panama Convention, for example, as because I choose just pure Panama Convention, it chooses a set of rules too. First, like New York Convention doesn't do that. So there's things to think about. Talk to your in-house counsel, talk to outside counsel, people that handle these on a daily basis, and I think you'll be surprised that there could be better ways to protect the business.
And coming back to where we are, right? Houston and Gulf Coast businesses. What do you think, what business dynamics now make the choice of forum, choice of arbitration versus litigation particularly important?
Again, I go back to nuclear verdicts. If you can go to arbitration, and that is their risk concern, think about going to arbitration or setting yourself up to success. Texas now has the business courts, which really help, but the dispute has to qualify for the business court.
Can you tell us more about business court? Because as I said, audience is very international, so we cannot assume people know anything we say, actually.
So, for example, a couple of years ago, the Texas legislature set up a specific court, which in other parts of the world, this already exists, where there are specific courts to handle whether it's maritime, commercial, or just general, or just purely criminal, or just purely civil. So a few years ago, the Texas legislature set up a business court that handles certain types of business disputes. I think the minimum threshold used to be 10 million. I think it's now 5 million that has to be in dispute. And there's a couple other qualifiers. So what that is going to allow is if you had concerns about a generalist judge handling this commercial dispute, well, if you qualify now, you can go over to the business court and have somebody that have judges that are fully business court judges. They handle business disputes, which is great. I think that's going to make Texas a more competitive landscape. But again, as I said, if you don't meet that minimum dispute threshold, which I think is 5 million, $4,999, still a good amount of money for pretty much every business. So you still may want to be cognizant of, hey, I may not make it to the business court. I may be out of regular Harris County courts, which is not bad. I want to make it that I'm not complaining at all about Harris County courts. I'm just talking about some of the things people see. So you still may really want to consider the arbitration clauses for disputes that may not make it inside of a commercial setting, commercial court.
So I have a couple of questions left, and if our audience wants to ask questions, please use the chat of questions, answers and questions app, not app, how do we call it? So the chat button, right?
Yes.
So my next question is, can you share an anonymized example where choosing the right forum changed the outcome of the dispute or reduced the business disruption?
I can't think of one off the top of my head, but I think the opposite.
Okay, tell us the opposite.
So I was giving you the maritime example where the business did not choose to add an arbitration provision to its contract, employment contract, particularly with Jones Act C9. And the difference ended up being the potential for a significant verdict that could be outsized versus arbitration where you're far less likely to get outsized damages or something that's probably hard. At least I'll put it this way. By going inside of arbitration, that business could have reduced the leverage point to the other side, saying, well, I can go to a jury and get an outsized verdict. Whether they hold that verdict on appeal is a totally different question. But at least that would have been off the table. So that I think also that would have helped that business not face that exposure, which that one decision can completely end that business. Once all that money's gone, it's gone. So there's a lot of businesses that don't have endless amounts of money.
Of course, small or medium businesses.
Yes, and an outsized verdict it may be higher than whatever they bought for insurance, for example. So yeah, there's things to think about, at least in that case where I thought, and for example, I'm pretty sure every major cruise line in their employment contract now has an arbitration.
Yeah, that's very specific to the US because in Europe, the employment disputes are normally not arbitrable.
Yeah, well, and it depends on the dispute and how that employment arose and what that employment entails, because it may not be arbitrable depending on.
We have a question.
Oh, great.
Let's read the question from Matthew Allerson. Excuse me if I mispronounce your name. Thank you for hosting. My question is, in dealing with arbitration, is it normal to have to fly to a different country to represent a company? And in what cases would you advise a company to arbitrate outside of the US?
So, yeah, I think it's pretty common, especially, people choose Paris as their seat of arbitration.
Which they shouldn't.
Especially
from Houston.
For example, we were at a recent event where we're talking about how a lot of Mexican arbitrations we think should be held in Houston for various reasons. And Houston's a great place to do that. But yeah, it's certainly not uncommon to have that happen. And
yes, and in what cases would you advise a company to arbitrate outside the US?
I think if it makes more of a logistics sense, better access to certain information, people. For example, if everybody's in Singapore, you may want to go ahead and go to Singapore to prepare. Now, these days it's a little different because we have things like Zoom and various technologies allow us to be connected around the world. But I think there are times when it does make sense from a logistics standpoint just to go to wherever that arbitration is.
And I can add as a French lawyer that in some instances, French courts are maybe more arbitration friendly. So, for instance, you want to install a seat of arbitration in Paris to kind of prevent your award to be easily set aside. That may be an option, right?
Yes, and I don't think generally in the US, I mean, US is very friendly to
That's true.
arbitration. So this is generally why you want to go ahead and come to the US and have that, to your point, be able to enforce that document or that award if you get it. Versus other places, you don't quite know if you're gonna actually be able to hold that arbitration award, even if you were able to originally have an arbitration. They may end up setting aside for less than what a US court would do,
That's
or
right.
even a European court for them.
That's right. Now, coming to my favorite part of the discussion, Aaron, tell us about your favorite places in Houston, restaurants where you would bring your family, or restaurants where you bring your clients as well.
So, but people do not know, Houston weather is terrible, but the food is amazing.
Don't use that. I think Houston weather is wonderful in comparison to Doha, for instance, or Dubai. So
Okay, it's not quite as hot. But so yes, Houston food is amazing. That is one of the big benefits of having your arbitrations in Houston is you get a world-class food scene. Because of that, it's hard for me to pick a place.
but try places.
3 places. Oh, okay. Probably just too many. So the pit room,
What is
barbecue pit room.
Petro?
Yeah. So
Where is that?
it's over on Richmond.
On Richmond.
Um,
That's something new because a lot of people they mention Poche, Taste of Texas, but that's for the first time. Okay.
Number 2 is definitely Taste of Texas. I love
Okay.
Taste of
Mhm.
Texas. Then I'm trying to think of a
I guess
Texas.
I need to go there. I've never been.
To Taste of Texas?
Yes.
Oh my
I will go. I promise.
It is an institution of this city. There's
Okay.
for people that do not know, never been, Taste of Texas is a steakhouse. It's amazing. But what is really fun about it,
Mm-hmm.
they have Texas history pretty much just all over the walls. So you can learn a lot about Texas just by standing and waiting on your table. And then number
Right.
3,
Number 3,
I would say Ninfa's. It's a Tex-Mex place.
Texas. How do you spell it?
Ninfa, it's
Ninfa.
Ninfa.
Mm-hmm. And where's that?
I have a couple locations around the city,
Okay.
so
Okay.
if you want fajitas, then
Oh, and we have another question.
sure it's about food.
That's
See?
that's not the question. Has Ninfas has great Houston history too.
That is certainly true.
Perfect. Perfect. I see our time is coming to an end. So thank you so much, Aaron, for coming here and sharing your wisdom with us. And we will be this episode will be on YouTube channel and also on Spotify and Apple as a podcast, so you can listen to us again while driving or just share with your friends or colleagues. Thank you.
Thank you.